So today, the Supreme Court just dropped a 9-0 unanimous decision that's going to change everything about how the government can interact with you in your own home. Hit that subscribe button right now and turn on notifications, because you need to understand what this means for your constitutional rights. The unanimous decision that shocked legal experts. This morning at 10 a.m. Eastern, the Supreme Court released a decision that has sent shockwaves through the legal community. In Case v. Montana, all 9 justices, from Clarence Thomas to Ketanji Brown Jackson, signed onto a single opinion that fundamentally reshapes when law enforcement can enter your home without a warrant. To put this in perspective, the Supreme Court only reaches unanimous decisions in about 30% of cases. And when it comes to Fourth Amendment rights involving searches and seizures, that number drops to less than 15%. The fact that every single justice agreed tells you this isn't just another court ruling. What makes this even more significant is the timing. Right now, there are over 340 similar cases pending in federal and state courts across America, all waiting to see how the Supreme Court would rule on this exact issue. Justice Ketanji Brown Jackson wrote the opinion, and what's remarkable is that she managed to craft language that both the most conservative and most liberal justices could agree on. But here's what most people don't realize about this decision. The court didn't just settle one legal question. They actually addressed 3 separate constitutional issues that lower courts have been fighting about for years. And one of those issues involves a doctrine that police departments across the country have been using as a blank check to enter homes whenever they want. The dangerous loophole police have been exploiting. For the past decade, law enforcement agencies across America have been relying on something called the community caretaking doctrine to justify warrantless entries into homes. This doctrine was originally created for a completely different purpose. It was supposed to apply to vehicles on public roads, not private residences. According to data from the National Association of Criminal Defense Lawyers, warrantless home entries based on community caretaking claims increased by 340% between 2015 and 2023. That's not a typo. We're talking about a massive expansion of government power into your private space. Here's how this was working in the real world. Let's say a neighbor calls police and says they haven't seen you in a few days, and they're worried. Police show up, knock on your door. You don't answer because maybe you're at work or visiting family, or you just don't want to talk to them. In Montana alone, there were 47 cases last year where this exact scenario played out. In one case, police entered a home because a family member said the resident was depressed. They found legally owned firearms and used a state red flag law to confiscate them. The Supreme Court just put severe limits on this practice, but the way they did it is more complicated than you might think. What they actually said about community caretaking is going to surprise you, because they didn't just limit it, they completely rejected it as a basis for entering homes, and that has massive implications. What actually happened in this case will shock you. The case that made it to the Supreme Court involves a man named Trevor Case from Montana, and the facts of what happened to him read like something out of a nightmare scenario. On the night in question, Case's ex-girlfriend called police around 11 p.m., claiming she had a bad feeling about a phone call she'd had with him earlier. She told officers that maybe she heard a gun, maybe he said something about harming himself, maybe he mentioned shooting police officers. She couldn't remember exactly, but she just had this feeling something was wrong. 4 police officers responded to Case's home. Here's a critical detail that came out during the trial. All 4 officers personally knew Trevor Case. When they arrived, they spent 40 minutes outside his house. They knocked, they shined flashlights through windows, they called his name. During this time, they looked through the windows and saw an empty gun holster on a table and what appeared to be a notepad. Now here's where this gets disturbing. After 40 minutes of getting no response, the officers decided to enter through the unlocked front door. They went upstairs into a bedroom, opened a closet, and found Case inside. One officer claimed he saw a black object, which could have been anything: a phone, a wallet, literally anything, and shot Trevor Case. Case survived, but he was then charged with multiple crimes based on a gun they found in a laundry basket in that bedroom. If someone called the police on you right now because they had a bad feeling, should officers be allowed to enter your home, search your bedroom, and charge you based on what they find? The three different legal standards that we're battling. Before today's decision, courts across America were using three completely different standards to decide when police could enter homes without warrants in emergency situations. This created chaos in the legal system because what was constitutional in California might be unconstitutional in Texas, and what flew in New York might get thrown out in Florida. The inconsistency was so bad that your constitutional rights literally depended on which state you lived in. Legal scholars have been calling for the Supreme Court to step in and resolve this confusion for years. Standard number one was probable cause. This is the highest standard, the same one required for getting a search warrant. About 12 states were using this standard for emergency entries. The problem? By the time officers gather enough evidence to meet probable cause, the emergency might be over and someone could be dead. Standard number two was reasonable suspicion. This is a lower bar. Police just need specific facts that would lead a reasonable person to suspect something is wrong. Around 23 states were applying this standard. Standard number three was the community caretaking doctrine I mentioned earlier. Roughly 15 states were allowing this, and it was the lowest bar of all. But here's what nobody saw coming. The Supreme Court didn't pick any of these three standards. They created something entirely different, and it's a framework that's going to require police departments to completely retrain their officers on how to handle these situations. The new constitutional test. Every American needs to understand. The Supreme Court established what they call the objectively reasonable basis test, and this is now the constitutional standard for the entire country. The court said that police can enter a home without a warrant if they have an objectively reasonable basis for believing that an occupant is seriously injured or imminently threatened with such injury. Notice those specific words, seriously injured and imminently threatened. This language is critical because it sets a much higher bar than what many states were using. This isn't just, we think something might be wrong. It's not, we have a bad feeling. It requires concrete, articulable facts that would lead a reasonable officer, not the specific officer involved, but any reasonable officer in that position, to believe someone is facing serious harm right now. Here's where this gets really interesting. The court outlined specific factors that should be considered. Was there a credible report of danger? What exactly was reported, and by whom? Did officers observe anything concerning when they arrived? According to legal analysts who've already broken down this opinion, the new test is actually stricter than reasonable suspicion, but more flexible than probable cause. It sits right in the middle, which is exactly what the Supreme Court intended. But here's the part that's going to cause problems in court cases for years to come. The court didn't define exactly what serious injury means or how imminent is imminent, and that ambiguity is going to be litigated in thousands of cases. Why the court ruled against Trevor Case despite changing the law. Here's the twist that has constitutional law professors debating today. Even though the Supreme Court rejected Montana's legal analysis and said they used the wrong standard, they still ruled against Trevor Case. The court said, yes, Montana screwed up the legal test, but under the correct test, the objectively reasonable basis test, the officers still had the right to enter Case's home. This outcome is significant because it shows that even under the stricter standard the court established, the officers' actions in this particular case were still constitutional. The justices pointed to 5 specific facts that supported the entry. First, the ex-girlfriend's call reporting potential self-harm and threats against officers. Second, the officer's prior knowledge of Case's mental health history. Third, the observation of an empty gun holster, which suggested a firearm was somewhere in the house. Fourth, the 40 minutes of no response despite repeated attempts at contact. The court said that taking all of these facts as a whole, a reasonable officer would believe that Case might be inside, possibly injured, possibly suicidal, possibly planning violence. Now, many legal experts are already criticizing this application. They point out that Case was under no obligation to answer his door. The dissent. Oh wait, there was no dissent because this was unanimous. But here's what's fascinating. Even though all 9 justices agreed on the outcome, some of them wrote separate concurring opinions, suggesting they might have concerns about how broadly this standard could be applied in future cases. If you're home alone late at night and don't answer a knock at your door because you're not expecting anyone, should police have the right to enter your home? The 340 pending cases that will now be decided differently. Remember, I mentioned there are over 340 cases pending in courts nationwide that involve similar warrantless entry situations. Those cases are about to be thrown into complete upheaval. Federal public defenders are already preparing motions to have cases reconsidered under this new standard. State prosecutors are scrambling to figure out which convictions will survive and which ones won't. Here's what's going to happen in the next 90 days. Every single one of those 340-plus cases will be analyzed under the objectively reasonable basis test. Cases where police entered homes based purely on community caretaking. Those are likely going to be thrown out. Cases where officers had solid, articulable facts suggesting imminent serious harm, those will probably be upheld. In the Ninth Circuit alone, which covers California, Arizona, Nevada, Oregon, Washington, Alaska, Hawaii, Idaho, and Montana, there are 73 pending cases involving warrantless home entries. State courts are going to be even more affected. The National Center for State Courts estimates that approximately 2,800 cases currently in state appellate courts involve Fourth Amendment challenges to warrantless entries. Defense attorneys are going to be filing motions for reconsideration, prosecutors will have to respond, and judges will need to reanalyze cases they thought were settled. But there's one category of cases that everyone is watching closely, and it involves a practice that's become increasingly common in states with red flag laws. And what the Supreme Court said today could completely upend how those laws are enforced. The red flag law implications nobody is talking about. Here's something that didn't get mentioned in the Supreme Court opinion, but is going to become a major issue. 21 states currently have red flag laws that allow law enforcement to temporarily confiscate firearms from people deemed to be a danger to themselves or others. The way these laws work in practice often involves police conducting welfare checks, entering homes, and then using what they observe to petition for firearm removal. Today's ruling just made that process significantly more complicated because many of those welfare check entries may not meet the new, objectively reasonable standard. Let me give you a real example from Colorado. Last year, police received a call from a family member saying their adult son was depressed after a breakup. Officers showed up at his apartment. He didn't answer. They entered under community caretaking, saw firearms in plain view, and initiated a red flag petition. The guns were confiscated for a year. Statistics from Everytown for gun safety, which supports red flag laws, show that 37% of red flag petitions originated from police-initiated welfare checks, where officers entered homes and observed firearms. If a significant portion of those entries don't meet the objectively reasonable basis standard, those red flag petitions could be challenged. On the flip side, advocates for domestic violence victims are concerned about a different issue. In many domestic violence situations, victims are reluctant to let police enter their homes even when they're in danger. The court's decision creates this tension. It protects privacy rights, but potentially at the cost of intervention in some situations where intervention is needed. Over the next year, we're going to see how this balance plays out in real-world scenarios, and it's not going to be pretty because both sides have legitimate concerns. What this means for your rights starting today. Let's get practical. What does this ruling mean for you as an individual American starting right now? First, if police show up at your door and you don't want to talk to them, you generally don't have to answer. The simple fact that you don't respond to knocking is not, by itself, enough to justify entry. This is a crucial protection that the court has now clarified applies nationwide. Second, if someone calls in a welfare check on you, a neighbor, an ex, a family member, police can't just automatically enter your home. They need to have objective reasons to believe you're facing serious harm. A vague, bad feeling or concern isn't sufficient anymore. Third, and this is important for gun owners, the mere presence of firearms in your home, even if visible through a window, is not grounds for warrantless entry. Millions of Americans legally own guns, and the court recognized that firearm ownership alone doesn't create an emergency. However, and this is the critical caveat, if there are multiple factors present, someone reports you're suicidal, officers see a gun, you're not responding, there are other concerning circumstances. Those factors combined might meet the objectively reasonable standard. Fourth, this ruling doesn't affect other warrant exceptions. If police have probable cause that you've committed a crime, they can still get a warrant. Does this ruling strike the right balance between protecting your privacy and allowing police to respond to genuine emergencies, or did the court get it wrong? So that's the complete breakdown of this massive Supreme Court decision and what it means for your constitutional rights. If you found this analysis valuable, smash that like button, drop your thoughts in the comments below, and make sure you're subscribed with notifications on so you don't miss future Supreme Court rulings that affect your freedoms.